Okay, so did you revise yesterday's thing? I mean, did you find any doubt? It's clear, right? Okay, so let's quickly revise. Open your notes on first page. So we had started this salient features and we have derived certain syllabus based on the previous year question. And for the first topic we had discussed was the constitution, its definition. It's nothing but a set of law, right, which regulates the actions of not only the state but also the citizens. Then this constitutionalism, which is nothing but the principles, basically the values through which the constitution or the states are regulated, and through this, by following this system, principles, whatever government runs, that is called as the constitutional government. For example, India's government is a constitutional government, right? And they work under certain limitations, and that is why by definition it's a limited government. Okay, not like the extraordinary power is not there. Constitutional morality is a non-legally binding, that we have to remember. It's not legally binding, it's morality. And as we know, morality doesn't have the legal enforcement. Similarly, this doesn't have the legal enforcement but still influence our decisions. This constitutional government we discussed, and then we came to the second point, that is the making of Indian constitution, which has the three areas we identified which influence the making of Indian constitution. Constituent assembly, which played the major role. We have borrowed from the different places, and the historical underpinning. This we are going to cover in modern history. These two we have covered. First we discussed about this constituent assembly, which is having the symbol of elephant, and it has certain features like it has indirectly selected from the provincial bodies, provincial assemblies. We saw this flow, and the person who first floated this idea of constituent assembly was M.N. Roy. Okay, and then in principle acceptance in which August offered, and it was inspired from the cabinet mission plan, finally accepted in cabinet mission plan. Then we came to this important dates which start from the when the first formed constituent assembly, the 6th December, the date is not important, but 1946. And over the time we appointed the first person. Who was the first person appointed as president? Sachidanand Sinha. Then first elected one, Rajendra Prasad. First elected Rajendra Prasad. And finally, after this adoption of constitution, the first one who came to be as the speaker of Lok Sabha, Mavlankar. That three names we have to remember here. And then going to the objective resolution, who floated objective resolution? Jawaharlal Nehru. And it is the precursor of preamble. It's the precursor of preamble. If you go to the series of events, like the constitution was adopted in 1949, then it came into force in 1950, 26th January. That much we had discussed. And it took 2 years to 18. 2 years, 11 months, 18 days. These are certain facts. We saw that the total 389 were there. Princely states were given the seats, but they didn't join. Okay, that means while making of the constitution, they did not participate. Later on, they participated. These were some functions performed by Constituent Assembly. The thing is that they ratified India's membership to the Commonwealth. Second, they adopted Indian flag. They adopted national song and national anthem. They elected Dr. Rajendra Prasad as the first president of India, and they performed as the provisional parliament for the time till 1952, May 1952. These are the important committees. Let's see quickly the names. Dr. B. Ambedkar of drafting committee. Second name was Gopal Krishnan Iyengar. Quickly see that, that's very important. Gopal Krishnan Iyengar, Aladi Krishna Swami Iyer, K. M. Munshi, Sayyid Muhammad Sadullah, N. Madhav Rao, T. T. Krishnamachari. Okay, we keep seeing these names. Jawaharlal Nehru had the three committee: Union Powers Committee, Union Constitution Committee, and States Committee. Pandit Sardar Patel had the Provincial Constitution Committee and the committee which was related to the minorities, fundamental rights, and the tribal affairs. Dr. Rajendra Prasad, like a speaker presiding officer, he led the Rules Committee as well as the Steering Committee. Then enactment and enforcement difference we saw in the previous class. We saw these questions we have solved, and then we went to the features borrowed. The key features like the Government of India Act is a major one, where the historical thing like judiciary, governor, federal scheme, these are important. From the Britishers we have adopted the parliamentary thing, parliamentary and cabinet major. From the US we have adopted the Supreme Court related, judiciary related and the rights related. When it comes to the IRIS, three very important: DPSP, nomination, and the third is the method of election of president. Method of election of president. Impeachment of president? US. Removal of judges also? US. These two, that impeachment of president and removal. Okay. And the election of the members of Ajay Sabha? Canada. Election of members of Rajya Sabha. South Africa. Okay. So from Canada we have taken this center inclination, federation with strong center residuary power, appointment of state governors, advisory jurisdiction. Okay. Australia, this joint wala thing, concurrent in the joint setting. Weimar, that suspension of rights. USSR, we know the duty and the justice. French, the declaration, federalism and republic and liberty, equality and fraternity, LEF. South Africa, procedure for amendment and procedure for election of member of Rajya Sabha. Two procedure we have taken. And Japanese is the procedure established by law. The structural part is from Government of India Act 1935. The philosophical part from the two, IRIS and US, from where we have taken the fundamental right and the DPSP. Political part, the British system. Then we came to the next micro topic, that is parts of Indian Constitution, which is very important. Let's quickly see the part 1, Union Territories, part 2, Citizenship, part 3, Fundamental Right, 4, DPSP, 4A, Fundamental Duties, part 5, Union Government, part 6, State Government, part 7, no, repeat, part 8, Union Territories, part 9, Panchayat first, Panchayat, part 9A, Municipality, part 9B, Cooperative, part 10, Scheduled Tribes, Scheduled Areas, right? Then part 11 will be Center-State Relation, those things will come. At least 10 we should be very clear, like the Scheduled Area still. In the next class, we'll revise this part, because once in one time we won't do that. Schedules we have covered. The first schedule is related to, quickly, first schedule is related to names. Second, oath or privilege? Let's take as a privilege, one word to remember. The privileges, emoluments, privileges, those things. Privileges. Second, third, oath. Fourth, Rajya Sabha membership. Fifth, scheduled areas. 6, Assam, Meghalaya, Tripura and Mizoram. 7, this is very important, 7, the list, 3 lists, we have to remember, 7 means 3 lists, okay. 8, languages, 22 languages are there. 9, that protection from the judiciary. 10, anti-defection, 10th, anti-defection. What was the amendment? 52nd amendment. 9th schedule, what amendment? First amendment. Don't forget that. First amendment. The 10th schedule is 52nd amendment. Then 11th schedule, Panchayat powers. Which amendment? 73. And 12th schedule, municipalities power, 74th amendment. Next is the micro topic, amendment in the constitution, how the amendment takes place in the constitution, right? So that we discussed, like what are the features, like the first is that it is nothing but the modification of the constitution. Then why it is required, because we consider our constitution as the living document. Then how it is amended, through the amendment bill has to be passed. Then from where we have borrowed South Africa, and then the can Article 30 be amended? Yes. 368 we saw what are the features, 3 things: addition, variation and repeal. Then the power to amend any provision of the constitution as well as the procedure it gives. 368(3). Here important thing is that the whether the constitutional amendment bill can be considered as a law under Article 13 or not, that has been clarified in this. Type of majority, we saw the simple majority, it will not be considered a part of Article 368. These two will be the part of Article 368. Here 50% plus 2/3. It is a membership, remember, it is a membership, it is the member present and voting. The difference. Here 50% state are required, but is there a specific time within which they should reply? There is no timeline. That's a critical fact we have to remember. No timeline is there. Okay, so that is there. The next, these are the provisions which requires the different majority. Procedure of the constitutional amendment, we discussed 3 stages are there. First, introduction, second, the pass the bill, and third, the assent. Important features are there, very important. Joint sittings are allowed or not? Not allowed. Joint sitting, not allowed. President recommendation, not required. It is binding on the president to give the ratification, assent. They cannot reject also, they cannot return also. This is a very important fact because it came through the amendment, and very, very critical fact. State government cannot start the amendment procedure. Joint sitting is not there. Both majority required, special majority, that much we know. No timeline has been given, yes. And today we'll start with this, the major constitutional amendment. We'll start with the first constitutional amendment, which we know, but some features are required, and UPSC asks one question on it also. So it is very important. See, 2 important things is there. Basically, 3 things are important here. The number 1, we are discussing the first is the first constitutional amendment act, that is 1951. Okay, what we don't have to go a lot of detailing. We know already the context. They are trying to do some constitutional, the land reforms, but there were legal challenges because of the fundamental right provision. That is the context behind this. So to do that, what they bring, introduction of 9th schedule. Right, this is the first changes they brought, 9th schedule. Within the 9th schedule, they introduced Article 31, Article 31A and Article 31B. These are nothing but to acquire the properties, private properties, without giving compensation at the same time also. Right? So 9th schedule and this 9th schedule we already know. These 3 things will cover in the fundamental rights. But remember, these are nothing but to bring the land reforms. Objective was what? Land reform was objective. This much we need. The second important fact is that they also changed the fundamental rights. See, this is also the change in fundamental rights only, right? They are making change in the fundamental rights chapter. The second important thing they brought is that in Article 19, amendment to Article 19. If you remember, Article 19 is what? Freedom of speech, expression, and there are some other like the assembly, association, and those all things are there. Now within this is Article 19(1). Okay, within this then there is Article 19(2) is there. Article 19(2) gives certain ground for reasonable restriction. It contains ground for reasonable restriction. Now, what is the meaning of reasonable restriction? Article 19(1) gives us the freedom of speech and expression. Does that mean that I have the freedom or liberty to speak anything? Yes or no? No, right? I should be having certain restriction, right? Like I should not be able to speak anything which is causing certain harm to others, right? But now the thing is, who will put restriction on my speech? Government will put. Can the government put restriction on my speech on any ground? If they will do that, then my freedom will be curtailed. I am criticizing government and then they are putting me as the restriction, no, you can't speak. Then where is the freedom? Where is the democracy, right? So the thing is that's why there should be restrictions, but those restrictions should be reasonable. Reasonable. For example, public order is a reasonable ground, right? So there were certain grounds under Article 19(2) to put the restriction on any form of speech. So what this first Constitutional Amendment Act did is that they added 3 more grounds. So that is very important because recently Honorable Prime Minister criticized the Congress. I mean, that was a political debate. Like they are the one who started curtailing the freedom of the people by putting the more grounds by the first Constitutional Amendment. So here, what they did is that introduction of 3 more grounds to restrict the freedom of speech and expression. What were the 3 grounds? They added the number 1, 3 ground added. First was public order. Public order. The second was incitement to an offense. And third is relations with foreign state. These are the 3 grounds they introduced. In addition to the previously what were there, like the integrity, unity of country, certain things are already there, but 3 are added, and this is important. They can ask like which among the following were introduced to this, because it was the first one and it was a significant one which impacted Indian polity for the long time. Right, so that's why it is important. Incitement for an offense means certain speech which is inciting the people, encouraging the people to adopt the violence. And that relation, suppose if any speech is harming our relation with the other country, we are developing the very strong relation. Defense pact is signed as well as the trade pact is signed with which country? European Union. Right, yesterday only it happened. Now if any person or a leader is giving such a hate speech or such kind of speech which is damaging the relation with the European Union, that can be curtailed because it is harming our relationship, right? So that is the thing. Now let's go to the second important amendment, that is the 7th Constitutional Amendment. Second is 7th Constitutional Amendment Act 1952. Yes, 1952. 7th Amendment. Here the problem arises in 1952 is that in the constitution, especially this High Court, the provision for the High Court. Currently, if you see, there are some High Courts which look towards the more than one country, one state. Can you give any example of any state? Bombay High Court. It sees the Maharashtra and Punjab, Haryana, Chandigarh High Court. There Bombay also correct, but it sees the union territory of the Nagar Haveli and that region, right? So this Chandigarh High Court is very important because it sees the 2 states, almost around 2 states, right? So such kind of provisions were not there earlier, that whether one High Court can look at the more than 2 state or not, or the more than 1 state or not. So establishment of High Court was very, very costly. It was very costly, right? So because of it is costly, and the region, if the state is very small, there is feasibility challenge was there. So through this amendment, what they introduced, number one is that one high court for more than one state or duties can be done. Okay, this is the first thing. The second thing is that abolished classification of states into groups. In group A, B, C. Earlier, you remember Cabinet Mission Plan made this grouping of the states based on the regions. So they abolished this. So these two important changes they made. Okay. Next is the 24th Constitutional Amendment Act 1971. Next is 24th Constitutional Amendment Act 1971. Here they have made two changes, two important provision. Number one, as you know, this is during the Indira Gandhi period, in which the Indira Gandhi became very, very powerful, and they started curtailing the power of Supreme Court, the High Courts, right? So here the two changes. One is that made unlimited power to Parliament to amend any provision. Constitution. The second is related to the Constitutional Amendment Bill. What change they made? What change they made? This is the thing. To amend any provision, and they cannot have the judicial review. But the judicial review was abolished, so we can't add here. Because judicial review is a basic feature. Later on it was abolished that you cannot take away the judicial review. Yes, you can amend. You can amend any provision, we are not stopping. But we can review it. And if we found that it is violating the basic feature, then we can nullify that particular provision. So judicial review, they did it, but it was nullified. But it was kept. Article 368(3), it was kept. The second thing they did, if you remember, the Constitutional Amendment Bill made it binding on the President to give assent. Constitutional Amendment Bill made binding on President to give assent. That you have to give assent. This we have covered just a few minutes back also. So these two important amendments. Okay. Now 42nd Constitutional Amendment Act 1976. 42nd. This is very important amendment we have to know. Let's start with it has made it is also called as what? Mini constitution, because of the significant changes. So let's come from the beginning, from the start. Let's start what they made the change in the preamble. In the preamble, what change they made? They introduced different words. What are the words they introduced? Socialist, secular, and then integrity. Not only unity, but also the integrity of the state. Integrity. These three words introduced: socialist, secular, integrity. That means these three words were not the part of the preamble in the original constitution. Okay. So this is the first thing. Second, let's go to the preamble is done. Citizenship, no changes. Then what is the next chapter? Fundamental right. Did they make any changes in the fundamental right? Any significant change in the fundamental right? No significant changes like to remember. Next comes the DPSP. They introduced certain DPSP. Okay. The first introduction, they made changes in Article 39. Article 39. So what they make? Healthy development of children. This is the first thing. Second, they introduce Article 39A, that is free legal aid. Free legal aid. Then third change, Article 43A, that is participation of workers in management of a company. Then they introduce 48A also. 43A, then the 48A. Article 48A. They introduce what? The protection of environment. See, I am not writing exact terms there, not required, because they will be giving option. We just need to know the key thing there. That's why we need to create the notes like this so that it's easy to memorize. Then the third thing what they brought, fundamental duty. It was added, they added Article 51A. And how many duties they added? Currently how many duties are there? 11. 10 they added, one later on added by the Atal Bihari Vajpayee government. Okay, so the 10 duties added. Article 51A, one article they added, that is the one thing they introduced. Then next change they made was the tribunal. They added tribunal system. And there, what was the part? Part 14A. Let's check this. See here, part 14A, tribunals was added. These two articles they added. This was not the part of it. 14 is the services, like the public services. Within that, this tribunal system was added. Tribunal, you know, these are the quasi-judicial system. That means who will be looking towards the legal as well as the administrative aspect to deliver the justice. Like the CAT is there, you know, Central Administrative Tribunal. Suppose tomorrow if you have any issue regarding posting, promotion and these all things as an IAS officer, you have to go to the CAT, right? So that is tribunal. So they added part 14A. Part 14A added. Within this, Article 323A and Article 323B was added. What was the part for the emergency? Check your notes. What is the part for emergency? Part 18. Yes, part 18. They made changes in part 18. Part 18. What changes they made, we will cover in the emergency chapter. That we have the specific chapter for this, because otherwise, because they have made so many changes. If we cover here, it will be too much complex. That much is not required. But what today we got to know is that very easily you can now figure it out, like the what changes they have made, because we are going in the flow. Preamble first change, then DPSP second change, third fundamental duty, fourth tribunal, fifth emergency. These are the 5 major changes which were very significant, and that's why this 42nd Amendment Act is also called as the mini constitution, right? This can be very important if you have this same data for your mains also now. Like why 42nd Amendment Act is called as the mini constitution, you can easily justify by writing these points, right? So for mains also keep the same notes, it will be helpful. Next is the 44th Amendment. What was the number? Fifth is 44th Constitutional Amendment Act 1978. 1978, yes. important changes. Number one, related to the fundamental right. What the change is that deleted what? Fundamental right to property. They deleted fundamental right to property from part 3 and made it legal right under under article 300A. Under article 300A. Legal, or you can say the constitutional right, constitutional right, because it is the part of the constitutional right or the legal right under article 300A. It's not anymore the fundamental right. Please remember, it was through the 44th constitutional amendment. The second thing is that they made changes to part 18, restoring emergency and strengthening emergency provisions. Okay, you know that they brought it back or made it more significant. Okay, these two changes. This is very important, guys. Please remember, this is very important. Right to property. The next is that 6th, right? 52nd Constitutional Amendment Act 1985. This context, you know, Ayaram Gayaram, right? This is the, remember what it introduced. Number one, it made changes to the related to the disqualification of the members. It introduced which schedule? 10th schedule, please remember. So the first thing it introduced 10th schedule, that is anti-defection law. Now what is anti-defection, and those all things we'll cover in the separate provision, but here the 10th schedule is, remember, it introduced, and second, amended disqualification provisions. In part 5 and part 6. Part 5 and part 6 is, part 5 is related to union. Union, within that parliament will come. Within parliament, MPs will come. Within that, it is written how the MPs will be elected, how MPs will be disqualified, right? So that they have to change article part 5. We don't need to remember the exact article. That I don't think UPSC is going to ask that much detailing. But which part they made changes? Part 5 for the union, part 6 for state, because MLS has to be changed, their disqualification thing. Next is 61st Amendment Act. 61st Constitutional Amendment Act, which year? 1989. Only one thing, remember, the electors' age was increased or decreased? Decreased from 21 years to 18 years. That means more people started giving the vote, more people became the eligible. Next, 8th is 69th Constitutional Amendment Act. 69th Constitutional Amendment Act 1991. Now this was related to this you understood, this is not required constant. Basically more demand was there, like the more participation of people in the electoral system. Now this Constitutional Amendment Act was related to the National Capital Territory of Delhi. See, the Delhi was the capital, so it has the demand for a better governance, like it should be more regulated and more control of the center should be there, as well as some form of autonomy should also be given. So here they introduce the hybrid model of governance. Hybrid model of governance in which both center plus state government will be there. Why this constitutional amendment is important is because of the Delhi keeps on in the news. Now it is in the less because of the BJP government has formed. Earlier Aam Aadmi Party was there, opposition was there, so highly controversies were there. So here 69 Constitutional Amendment Act, it introduced this system of hybrid governance in Delhi, and there this conflict and this all thing started. So this made the special provision for this particular segment. 9th, then the 73rd Constitutional Amendment Act 1992, and here we know there are two things. One is that which part introduced? Part 73rd, 9, part 9, okay. Schedule 11, okay, this two, part 9, schedule 11. Then 10th, 74th Constitutional Amendment Act 1992, quickly, part 9A, schedule 12, simple, we don't need much detail here. Next is 86th Constitutional Amendment Act 2002. Remember, this is related to education. This is related to education, right to education. So, to do the right to education, 3 changes made. Number 1, they changed the fundamental right. What they introduced? Article 21A as right to education. Okay, right to education introduced. The second change was DPSP. There is Article 45. Article 45, which were earlier gave the instruction, as we know the DPSP gives the instruction to the state, that is government, to provide certain services or the rights to the people. Instruction is there. Earlier, before this amendment, the instruction was to give the education for the children, promote the education. What age here? 6 to 14 years. Earlier, this subject matter was the state has responsibility to provide the education to the children between 6 to 14 years. Since now this 6 to 14 years age education has been transferred to the fundamental right chapter, that is part 3, it was transferred. So what they did is that they changed the subject matter of this, and what they made that early childhood care and education for 0 to 6 year children's. That means earlier this right is already provided. So now they thought like let's give the responsibility to the state for the early childhood care and responsibility. So this is called a ECCE. This system has been introduced here. Okay. Earlier it was there. Clear? So they just changed the subject matter. Third is they changed in the fundamental duty. They introduced 11th duty on parents or guardians to educate children. To provide the opportunity for their children to get education. So duty. 3 things. This is the article 51A. What will be the last one? 51 A, B, C, D, E, F, G, H, I, J, K. It would be K. K was introduced. 11th. Next is 97th. What is the number? 11th, na? 12th. Is 97th Constitutional Amendment Act. This is also very important. 2011, I think. It's 2011, yes. This also changed the first. It changed the fundamental right before that, let's introduce. It changed the part, new part introduced. It is related to what? Cooperative. Okay. At least one word you should remember. 97th is related to cooperative. 86th is related to education. Okay. So cooperative. They introduced new part. Which part? Part 9B. A is municipality. B introduced. Second, they changed the fundamental right within the part. They changed Article 19(1)(c). Here, you know that there is fundamental right to speech and expression, assembly, and third is association. So within association, so here what they introduce, right to form cooperatives. Basically, they said like the cooperative is also kind of association. So within that, they have introduced another ground as a right. It is our right to form the cooperative. So that's the first change they made. Third is DPSP. So in DPSP also 43B was introduced. Article 43B. State to promote cooperative. They gave the instruction to the state to promote the cooperatives. So these are the three changes made. Clear? Next is which number? 13. 13 is 99th Constitutional Amendment Act 2014. Just we have to remember it was related to NJAC, National Judicial Appointment Commission. It was changing Article 124. Part, which part? Supreme Court is in which part? 5. Union. It will come in the Union. High Court will come in state. Then 14. 100th Constitutional Amendment Act 2015. It was related to land boundary agreement with Bangladesh. Actually, what we have done is that we have exchanged certain enclaves, that is some certain territory with Bangladesh. They give certain territory to us, we give to them. So since we are ceding certain part of India to them, it required the amendment of the constitution. This was related. I think I will be having certain images of that. No, okay. 15th is 101st. It is related to GST. 2017, right? GST was introduced. GST and GST Council. GST Council was also, this was 279A, I think. Yes, GST was introduced. 1st July 2017. 16th, that is 102nd Constitutional Amendment Act 2018, I think. So here it is constitutional recognition to National Commission on Backward Class. National Commission on Backward Class. Earlier it was just a statutory body. We gave the constitutional recognition. Then 17th, 103rd Constitutional Amendment Act 2019. 2019. It was related to EWS, 10% reservation. They amended Article 15 and 16. 18th, 104th Constitutional Amendment Act 2020. This is not very important, just the extension of reservation for SC, ST in the Lok Sabha and State Legislative Assembly. So they every 10 years they extend that because it's a temporary provision. Then 105th. Since these are recent, that's why we are remembering, not very significant. 105th Constitutional Amendment Act 2024. 21. It is related to power of state. Socially economic backward class without permission of National Commission on Backward Class, without consulting National Commission on Backward Class. So that means, see, due to certain Supreme Court judgment, what happened is that the state government lost this power to identify the backward class, that is especially this OBCs, to update the list. Because of that 102nd Constitutional Amendment Act, which gave the power, some certain power to the the National Commission on Backward Class. So they made this change. Then remember this 20th, that is 105th Constitutional Amendment Act 2021. 106 Constitution 2023. This is nothing but the Nari Vandan Adhiniyam. Nari Vandan Adhiniyam. That is how many? 33%, right? Reservation for women in Lok Sabha and State Legislative Assembly. So these are 20 important amendments. I think more than enough to cover. Almost all important amendments we have covered, and only the crisp point, not the detailed thing, is there. 107th is on the way. That you remember, like if any minister got the jail for certain period, then they have to leave their post. That is the law which is under the debate, but that has not yet come in the form of the act. So until and unless it has not been in the form of act, it's no point. The UPSC is not going to ask, because bill can be repealed, can be made changes. So they don't ask on the bill, they ask on the acts, because these are final. Okay, so these are the important. Let's revise by solving some questions. See, 2023 question. What is the answer? Constitution was widely believed to be enacted to overcome the judicial interpretation of the fundamental right. What is that? First Amendment, right? It was related to the fundamental right. First Amendment. To be honest, 2023 I have put the First Amendment only. But what is about the 42nd Amendment? Was it not related to the fundamental right? Widely believed to be enacted to overcome the judicial interpretation of the fundamental rights. Actually, it also interpreted in a way that the judicial review power was taken by 42nd Amendment also. To give the, see what happened is that 1971, which amendment came? 24th, right? Constitutional Amendment Act came. After this, what happened? Here they curtailed the judicial review, as you said. Then what happened in 1973? What came? Case 1 and the Bharti case came. They said no, judicial review has to be there. It is the fundamental thing. Then in 1976, what happened? This 42nd came. They restored this again. There is no limitation on the power of the Parliament. No limitation on the power of Parliament to amend any provision, including fundamental right. So even the 42nd was also impacting significantly the fundamental rights. And that's why the UPSC dropped this question in 2020. Because they initially many answers told the First Amendment only. because it was significant. But when you see the 42nd, which is the mini constitution, has also impacted the fundamental right significantly. So you can't say that this only correct, this can also be correct. 86th amendment is related to what? Education. That means it has also impacted the fundamental right significantly. What it is saying, widely believed to enacted to overcome the this is not judicial interpretation. These two only correct, because it's asking about the judicial interpretation. Here the judicial interpretation was not there. So this question was dropped by the UPSC, but that's not important for us. What is important for us is that they can ask on the amendment. An important amendment we should be aware, right? That's why we have covered that, and not once. They have asked multiple times, like the CDS. Which of the following provision of Constitution of India need the ratification of legislature of not less than 1/2 of the state to effect amendment? The manner of election of the President of India. Does it require? What it's saying? Need the ratification. Yes, it needs, because it impacts the state interest. Extent of the executive power of the union and state. Yes or no? Yes, right? I mean, up to what extent a state will have the power, executive power? If they change, will it impact the state or not? Yes, so it is also required. Powers of the Supreme Court and High Court. If they change, let's say, power of the Supreme Court, High Court, will it impact state or not? Yes, it will impact. Otherwise, what it will happen? The center can take powers in their hand, and the state cannot go there to the Supreme Court, High Court. There is one article 131. It gives the original jurisdiction to the Supreme Court, that whenever the state have any problem with other state, or state have the problem with the center, they don't need to go to the High Court. They can directly go to Supreme Court. Suppose they change this power, this provision of the Supreme Court, will it impact the state or not? Yes. This is also correct. Any of the list in the 7th schedule? Yes. So 1, 2, 3, 4 all are correct. Clear? So this is the direct question. Then consider this we had solved yesterday, right? We had solved yesterday. Next, there are provisions in the Constitution of India which empowers the Parliament to modify or annul the operation of the certain provision of the Constitution without actually amending them. They include, this we have not yet covered. It is basically the amendment beyond Article 368, which requires a simple majority. That is saying, without actually amending the Constitution. Whenever you use Article 368, it actually amends the Constitution. You have to add the part or delete certain part. But except that also we can do certain amendment, like Article 2, that regarding the admission or establishment of the new state. Then any law made under Article 3, yes. Amendment of the 1st schedule and the 4th schedule, yes, it is also correct. So 1, 2, 3 are correct. This we have actually, when we will cover this union territory, this Article 2 and 3, there is Article 4, which says that any amendment to this 2, 3 will not be considered as the constitutional amendment under the definition of Article 368. This is mentioned. So when we will cover the next chapter, you will get the clarity. And when you amend Article 2 and 3, actually you have to amend 1st schedule and 4th schedule. Article 2 talks about admission of the new state into the list. New state you are admitting. For example, Sikkim was not originally part of the Union of India. Later on in 1971 or the 74, I am not sure, we added the Sikkim. So to do that, we have to amend Article 2. When we will amend Article 2, we have to update the 1st schedule. First schedule is related to names of the territory. So now you are admitting new state. So you have to update that. Now when you update the 1st schedule, you have to update 4th schedule. 4th schedule is related to Rajya Sabha seats. Now you have to give one Rajya Sabha seat to Sikkim or new state. Right? So for that, changes are required here. So when you are making changes here, automatically you have to make change here. For example, under using Article 3, the Telangana was separated from Andhra Pradesh. Article 3 talks about separate one state into multiple. Article 3 only used by the Union to bifurcate the Jammu and Kashmir to Union Territory of Ladakh and Jammu and Kashmir. Now to do that, suppose the Andhra Pradesh was separated into two. Now you have to change the first schedule, add the name Telangana, and then the fourth schedule, divide the Rajya Sabha seat of Andhra Pradesh between Telangana and Andhra Pradesh. Both doesn't require the amendment using Article 368. Getting the clarity? Yes. Next. Which of the following statement about the bill or amendment of the constitution is not correct? See this. B. Joint sitting is not required. Here it is very straightforward question. Which among is not correct? It is governed by Article 368 too? Yes. We have covered. Which part? Part 20, right? Then joint sitting can be? No, it cannot be. That ensures the rigidity of our constitutional amendment. Rigidity of constitution. Then state legislature cannot initiate? Yes. Cannot initiate. The provision sanction of the president, that is the previous sanction of the president of India, not required. Yes, not required. Okay, these things we have covered. So right answer is option B. Then with regard to the constitutional amendment bill, which of the following is not correct? Same question, I think. Yes, option A. Then you're getting? Which one? Election of president, is it required or not? It's required, right? Not less than 1/2. Yes, it is required. So one will be correct. This cannot be answered. Representation of the state in the parliament. Let's hold on. Any of the list of the 7th schedule required or not? Correct. So 2 should be there. So this won't be answered. Now 2 is correct. You have to be sure with 3 and 4. Now abolition of the legislative council of the state. Suppose they have to abolish the legislative council of the state. Will it require or not? Now, if you are not getting this, then a representation of the state in the parliament, it should require, no? Otherwise, it will impact the interests of the state, right? Representation, if you change, but abolition of legislative council itself is depends on the parliament, okay, and it doesn't require the huge amendment. So this is not correct. Abolition of the legislative council of law. So it will be the answer. Okay, next subtopic, micro topic is basic structure. Let's note down. What is first? What is basic structure? These are nothing but the core and fundamental provisions of constitution which creates the essence of the constitution. Key spirit of the constitution is derived from this. Now the question is, it is the core and fundamental. Now, is it defined? Is it defined? No, not in constitution, not by judiciary. Remember, judiciary also have not defined what is basic structure. The clear definition is not there. Not even by the judiciary, that is Supreme Court, High Court. They have not done that. Even the Constitution doesn't have originally this basic feature thing. These two all they need. Now, how this evolved? This doctrine of basic structure. As we know, this has come from what? Keswananda. Wait. Keswananda Bharti case, 1973. Okay, and this case gave that certain thing like your independence of judiciary. Similarly, judicial review, JR, judicial review, and supremacy of constitution. These are the certain things which are the basic feature as per the Keswananda Bharti case. Then there was very important case related to fundamental rights and duty, that is Minerva Mills case. (1980) Minerva Mills case. It said that the balance between fundamental right and DPSP is core of Indian Constitution. So that's why that's also the basic feature as per the Minerva Mills case. The balance between the fundamental right and DPSP. Next is the Woman Rao case. Woman Rao case, which year? 1981. You know, this interestingly, this said that it will apply to all, that is the doctrine apply to all laws post Keswananda Bharti judgment. Retrospectively, like see, Keswananda Bharti case came in 1973. Its judgment is 1981. So after that 1973, whatever laws has been passed, it will apply to those laws post Keswananda Bharti judgment. That was the Woman Rao case. Then this S.R. Bomai case also brought certain changes, or expanded the features of this basic structure. That was S.R. Bomai case, very popular case, 1994. This was related to the center-state relation, basically. Center-state relations related dispute was there. S.R. Bomai, you know, Karnataka chief minister he was. He filed one case against the center, and then this interpretation happened between the center and state relation. Here, they said that the federalism is a basic feature of Indian Constitution. So they brought this federalism as the basic feature. Second, secularism is a basic feature, that is the state should promote the secularism, not the religious policies, politics. Last is the IR Koino case. This is important. IR 2009 case, 2007, this case. This case is interesting because it says that 9th schedule laws are open for judicial review if they violate the basic feature. If they violate the basic feature. So these are the important cases. I think we should, it helps us to basically understand the basic structure doctrine in much deeper and understand it, what are the essence of this basic structure doctrine. Now, if you see, if it came in Kesavananda Bharati case, but later on it was strengthened using the different judgments. Now here, what are the different judgment which is strengthened? Yes, Kesavananda Bharati case brought it on the picture, but Minerva Mill's case expanded by establishing balance between fundamental right and APPSC. Then Woman Rao said that it will apply to all those cases retrospectively post the judgment, right? Not like from this. It will apply if any case has any law has been made post 1973. Then S.R. Bommai case was very significant. Remember, center-state relation. It gave the two addition to the fundamental that is the basic feature, federalism and secularism. I.R. Coelho is important because it's interpreted 9th schedule that you cannot immune those laws by putting them in the 9th schedule. If they violate the basic structure, we will review. Right? So the two things is happening. If you see the tussle between the judiciary and the legislature, number one, legislature have made their power unlimited by saying that we can amend any power, any provision of the constitution. So we have unlimited constituent power that is being said by the parliament. So it is called as the parliamentary sovereignty, parliamentary supremacy or the sovereignty. But then the judiciary came and they said like, yes, you can do that, but you cannot take away the power to review. That's our power, to review any provision if they violate the basic structure. So basically this provision is establishing the constitutional government. How? Because they are limiting the ultimate power of the parliament to certain extent. That yes, you can amend, but not completely. Certain aspect you have to leave. Isn't it a limitation? So whenever this limitation comes, it is a key feature of the constitutional government. And that way we are establishing a balance of power between the judiciary and the legislation, and that is the significance of this basic structure doctrine. This has actually helping to establish the constitutional form of government. Okay, so this is the essence and these judgments we have to remember, and very important from our mains point of view also. Because this question can be asked on the basic structure and related to the amendment. If you remember these judgment, this will help you to justify your arguments. These are the certain thing, but I don't think it is required now because we already have this. And if UPSC create question also, they will keep this aspect only. So we are already having enough point to tell that what constitutes the basic feature. These are the extensive list of whatever judgment they came. And if you have certain things are already there, already we have done that, like independence of judiciary, right? And there is separation of power between the legislature, executive and judiciary. Secular character, that is secularism. Federal character, federalism. These two came from the S.R. Bommai case, right? So similar thing would be there. You can easily eliminate options. You don't have to have these all things like supremacy of constitution, Kesavananda Bharati case, judicial review Kesavananda Bharati case. So limited limited power of the parliament to amend the constitution. It's a key feature, right? They cannot make their limited power to ultimate power. So these are the features. See the question. Statement 1 is wrong. Statement 1 is wrong. The second is right or wrong. Does it provide for judicial review? Yes, it provides. Constitution of India provides for judicial review to safeguard the citizen liberties, preserve the ideals of which the constitution is based. For example, Article 13, which says that if any law is made, which violates the fundamental rights should be null and void. Now, who will decide whether it is null and void? Courts has to decide whether it is violating Article 13 fundamental rights or not. So, to decide whether it is violating the fundamental right or not, the courts has to review the judgments, review the laws. So, it is implicit to the Article 13. This term judicial review is not explicitly mentioned in the Constitution, not specifically mentioned like the judicial review like that. But we can, the essence we can derive from the provisions mentioned in the Article 13 that they can review. Okay, so that is that way this is correct. So if it is asking the correct answer, option 2 will be the correct answer. Okay, so this was the basic structure doctrine. Not much thing is there. What questions can be asked, you saw here. I mean, first is the features of the basic structure, that it is not defined. It's a fundamental law. From where it originated, what are the key things in the basic structure, that question can be asked. But I think this also is difficult. Like, I don't think they are going to ask all this, because these are subjective, not well defined. Not well defined in the Constitution. Now, what happens is that, it's difficult for the UPSC to give the such kind of questions which are subjective. You know why? Because tomorrow there can be a case where they can they can change their judgment, because they can review their own judgment also. So now suppose they have said like the parliamentary system is a basic feature. Now there will be the new interpretation of the law, and then in the new judgment they can say it's not a basic feature. India can adopt the presidential feature also. So it becomes very difficult for the UPSC to put that question. Suppose in the April month they created the question. In the May exam happened. In the June month the Supreme Court judgment came and they changed it. Then the result will come in the month of next year, February. Then the answer key will come, or when the final result will come, there will be a lot of dispute over this. So they generally don't bring the questions from something which is very, very subjective, right? So they bring the definite thing from the Constitution itself. Otherwise, the interpretative thing can be, they have to drop the question, and that is very, very problematic thing for the UPSC to drop the question, because it is against their reputation, right? The people say like you are not able to create the 100 question and you are the UPSC, the top institution. So such allegation is not good for the UPSC. So this was regarding the first subtopic which we have covered today, that is the index we had created. Open the first page. What index we had created? Yes. So 6 topics we had, micro topics we had identified: Constitution, making of Constitution, parts of the Constitution, schedule, process of amendment, and the basic structure. These all aspects along with the PYQs and practice we have done. Now we'll go to the topic number 2, that is subtopic 2, which is the Union Territory and Citizenship. Okay, so second subtopic, right? The heading. I would suggest you to leave at least one page so that if any updation is there, you can update your notes. At least this much you can leave so that if any news come or the new point you get, you can update your notes so that you don't have to make sure that you make a note such a way that you keep certain space so that you make this as your final revision notes, because we are keeping very short also. So if you keep certain spaces somewhere like this, you can add sticky note and start from something like here, or give certain space. You can put a scale here so that later if current affairs is there or the anything addition is there, you can update your notes and use this only as your final note, because we are going in that process only, like we are keeping very short and you can quickly revise. Okay, so this is going to be our subtopic 2, that is union, its territories and citizenship. So first let's see what our analysis of the previous year question says. See, here the questions has not been very so many questions we have not seen in at least last 10 years. One question I found is that about the state, which we will discuss also, like that they asked the question on the definition of the state. Now what basically they have given certain statement and they said like the state, which among the following is correct. Now this question is from NCERT. Directly this definition is not there in your Lakshmikant, right? This question they asked from the state question asked from the NCERT. Now let's see, I think we have this PYQ also, so we can see that this. Yeah. Basic terms. See, in 2023, what question they asked was this one. So try to solve this. Is it visible? Solve this. Which one? A. A or D? Last one? A or D? Let's see A. State. Best define the term state. A community of persons, okay, a community of persons permanently occupying a definite territory, independent of external control and possessing an organized government. Now, okay, let's keep on hold, because in order to understand the correct one, we should understand also the wrong ones. A politically organized people of definite territory and possessing an authority to govern them, maintain law and order, protect their natural rights and safeguard their means of sustenance. Okay, that's also there, but the politically organized, this word is there. Next, a number of persons who have been living in definite territory for a very long time with their own culture, tradition and government. This you can easily eliminate, because this long time is very vague term. whenever you are asking for definition, there should be a definite thing. Definition itself, the meaning is definite, na? Definition, make it definite. So here it is taking a very long time. It's already subjective, so it cannot be a definition, right? So number of person also very, very subjective. Then a society permanently living in a definite territory with a central authority, an executive responsible to the central authority and independent judiciary. Here it is saying the central authority. Let's say there is no central authority, only local bodies are there. So does that mean we won't call that a state? Is it central authority is necessary?
No.
With a central authority, not necessary. Na? Without central authority also you can create a state where the local bodies are regulating. An executive responsible to the central authority, an executive responsible to the people can be there, right? To the central authority, an executive responsible to the parliament, for example, India. That's again is a subjective and not the correct definition. So D also you can eliminate. Here B is a politically organized people of a definite territory. When it is saying the politically organized, when it is saying the organized, non-politically also we can organize, na? Why there is requirement of the politically? And the politically thing, political word, it's not well defined. What exactly the political meaning here? So this politically word creates certain issue here in the statement 2. And possessing an authority to govern them, maintain law and order, protect their natural rights and safeguard them means other aspects are correct. But the politically, because other aspects are the functions of the state, but may not need the politically organized thing. Now, if you see the statement number 1, that is a community of persons permanently occupying a definite territory. It's not saying from long time, it's saying the permanently occupied. It may be from yesterday also. Yesterday only we found the new island, let's say, and we went there. And now we are permanently occupying that territory, the new island. And then what we are doing, that definite island is there, then we are independent of other, like the India is not influencing or the other country is not influencing in our matter. And possessing an organized government. It's not saying political government, it's not saying central government, it's not saying like the executive, it's saying that the organized government. Organized government can be centrally organized, can be decentralized organized, right? So this is the best definition. Now what I want you is that what we understood from here is that yes, there should be a permanent territory, people and it should be sovereign, it should not be from external influence, it should be having the organized government, right? And its function, the government function should be to govern them and provide them the basic necessities and public services. So that way we can define the state. So this is something that is confusing actually in the exam hall. When the pressure of time and the exam center pressure is there, it can confuse. But we have to be careful on the definition and we can get the answer on this type of question. So within this union territory, 3 things we are going to cover, that is within the subtopic, what we are going to cover is that so the subtopic 2, within the topic constitutional framework, topic is same, constitutional framework we are covering. Within that the second subtopic became, that is the 3 things we are covering here. Number 1 is that union, what is union, its territories and citizenship. That means we are going to cover part 1, part 2. Part 1 and part 2 will be covered till from article 1 to 11. Article 1 to article 11 will be the coverage. So here the first micro topic will be the union under Article 1, Part 1. This will be the first thing we are going to cover. So the Article 1 to Article 1, 2, 3, 4. Article 4, Union. Second, micro topic 2. This will cover state reorganization. Here we'll go little out of the constitution. We'll see certain commissions has been formed, like how this Andhra Pradesh has been, Telangana has been separated from Andhra Pradesh. What are the provisions? What are the laws? Constitutional Amendment Act is there. Which state was formed in which year? That question has been asked by the UPSC. So that aspect will cover here. Try to focus on those questions. Third we'll cover is the citizenship. Sorry, this is MT3. Micro topic 3 will cover the citizenship. Here we'll cover this census. Very important. And NRC, NPR, CAA, those all things, these are very important topic because in the news, census is also there, which we'll cover under this because it is in the news, and census question I think very important. 27 has been declared like the year of census. It is going to be census 2027. So that is the current affairs we'll cover here. And this Bharat India debate was there. So this aspect is becoming important from the current point of view. State reorganization not highly in the news. Demand and those all things is not very much in the news, but these two are in the news. So these three micro topics we are going to cover under this subtopic, that is union, territories and others. So we'll start with this definition. I want you to start with this micro topic 1, that is union and its territory Right, the micro topic 1, union and its territory 1. So start with this definition. State, exactly, right, the same definition given by the UPSC. Because UPSC tend to repeat its own thing. We have seen in the limited government. So better to keep the definition, underline the important thing there and keep as the revision topic. Community of persons, permanently occupying, definite territory, independent of external control, organized government is there. These are the 5 key features of a state. Five key things are there in this definition. Clear? So that much is only important here, and the rest of the thing, like the term, what is the meaning of union, what is the meaning of federation, those all things will cover as the part of the constitutional provision. Okay, now let's go to the thing first. The first article, we'll start under that is the Article 1. It defines the nation. So if the statement is like in Indian Constitution has the name, there is the definition of nation India's, yes, it has defined the nation, Article 1. How they have defined India, that is Bharat, shall be a union of the state. That means the name of the union, the name of the country has been defined as the India as well as the Bharat. There is not only Bharat, not only India. It has been India, that is Bharat. And when you read the Hindi text now, how it is written, it has written that India, Bharat, that is India. So both have the same value, same meaning. It's not like the India have the more name, as a name wise it's more value, and Bharat has the less value. It's not like that. Okay. So this is India, that is Bharat. So name is there, shall be the union of the state. Here the term is that it is saying that it is going to be the union of state, not federation of states. This is important. Union of states, not federation of state. Why? Why this? This is very important. Why it is called as the union of the state, not federation of state? It has the two meaning. Basically, as per Ambedkar, there are two reasons. Number one, Indian Union is not the result of agreement between states. Means that it has not happened like, okay, there are state 1, state 2, state 3, let's say state 4. They came together and said that let's sign an agreement and create a union or the federation. It has not happened like this. It has happened in the USA. In the USA, there were the different states. They came together, they signed an agreement. Okay, let's create a federation. So they signed it. But in India, it was already like this. We have created the states like this. So one union has been carved into the separate state. State 1, state 2, state 3, state 4, state 5, state 6, state 7, so on. That means union has been divided into small states for the governance convenience. We have not coming together. It's not a coming together federation. That's a clear difference. There is an agreement between the union and the states to form this union. However, union in India, union is already there. We are already united as a country. We have just divided into the state for the convenience of the governance only. Okay? This has very important meaning. See this. Now here if you see, the state have the independence, right? Because they came by their own will to form the union. But here, state doesn't have their own will. They has been divided by the union. That means they can be subdivided anytime. They can be merged. The state 1 and 2 can be merged by the union. They can be divided. Their name can be changed. Their area can be increased, decreased, can be increased. Right? They cannot come out of this union. They cannot seed from this union. That's why this makes that this diagram clearly shows the dominance of what? Union. And this was intentionally kept so that we can keep our country united. However, here the states have this more power. You're getting? And this is USA and this is India. Okay? Now, here this makes the two sense. One is that it is called as the indestructible union of indestructible states. However, here it is indestructible union of destructible states. Yes, these states can be destructible. Union cannot be destructible. So here states have no right to seat from union, that is separate from union, no right is there. Second is that union, that is parliament, can divide, alter or merge states without even the will of the states. That is the meaning we are drawing from that idea. So it's not a federation, it's a union. Clear this concept? Okay, so name is there and this concept is there. Yeah, schedule 1 we know, and then next is that territory of India means what? Then when we say the union, we understood, right? The first word we brought here, the union, right? We understood what is meaning of union. It's not federation, it's union. Then the second is what is the meaning of its territories? Meaning of territories. See, territories have three meanings. One, it includes, when we say the territories, it includes states. It's not only state, it also includes the union territories. It can include territories may be acquired but not included as state or UT. That can also be termed as the acquired territory. Okay, so three meaning can be there. It's not just state, it can be the state, UT or territory may be acquired later. Okay, so these are the states and territories. We know this, that's not required. See this question. This question we have solved, right? 21, definition of the state we have solved. Article 2, admission or establishment of new state. This is the subtopic micro topic 1 only, Article 2, admission or establishment of new state. Now see, when you have this union, one thing is that there are states already there. What if we want to add one state here? Let's say here Balochistan is there. Now we want to add as another state, or the UT or the acquired territory. We need to amend it, right? Because we have already defined what is going to be the territory of India. Now we want to have this, we are having this Balochistan in our country. Then you need to use the Article 2, that admission, you are admitting new or establishing a completely new state, right? So write this, it is the admission or establishment of the new state, which are not part of union currently. Which are not the part of union or its territory. They are not, but now we want to establish it. For example, now who can do that? That is important. Who can do that? Only Parliament have this power, not state. Okay. The next thing is that, for example, Sikkim was added as a new state. Sikkim was added as new state through Constitutional Amendment Act 1975 using Article 36 Constitutional Amendment Act 1975. This amendment was made and Sikkim was added using Article 2. Okay, so this Article 2 is simple. We have to admit the new one. Article 3 is, suppose existing state is there, how we can change it? So this is nothing but the modification of existing states. Modification of existing states. Like the formation of new state. It can be formation of new state, it can be alteration of the area, boundary or the name. Now here for example, new state formation. From existing territory. For example, Telangana from Andhra Pradesh in 2014, right? Similarly, name was changed. Name change can also be done. For example, Odisha was changed to Odisha in 2011. Odisha was changed to IAASA 2011. This made to Odisha, the name change. Even Mysore was there earlier. That changed to Karnataka. So name change requires Article 3. So Article 3, we can do these things. But now the thing is that what procedure is required? Procedure for modification in states under Article 3. What is the procedure? As we know, the procedure had three things. Number one, introduction. Where we can introduce? In Parliament. In Parliament. Either house of Parliament, it can be introduced. Not in state, remember. Okay, not in state. This bill has to be in the either house. Now, second is that President prior recommendation, that is the assent, is required or not? Yes, required. Please remember this, because here state interest is required. Now, why it is required is that because the state's interest is getting affected because of this. And whenever the state interest is getting affected, as the president is also the responsible to ensure the rights of states. Isn't it? The president is the head of states. That means not only the union, but also the states. So whenever the state's interest will be involved, and still there is the possibility of the president, still there is a two things can happen. See, state interest is involved where it is significant interest is involved. Then if you are amending, you need the ratification of the 50% state. But there are certain aspects where the state interest is involved, but the power has been inclined towards the center. For example, in the matters of finances, the matters of this amendment to their boundaries, here state interest is involved, but it also requires the center's power. In certain cases, if you observe the constitution, when you will read, you will find that the precedent recommendation has been identified. Whether it is a financial thing, whether it is this kind of boundary alteration thing, schedule areas related thing where the state interest is involved, but we see that the center has the more power. Since the president is sitting there to protect the interests of the state, their recommendation has been established. Okay, so such kind of idea you will find here. Okay, so here the introduction requires the prior recommendation of president. Now, what is that? The passing of bill. One thing is that their bill must be referred to state, that is the state legislative assembly. It should be referred to them, like for their permission, not the permission, you can say, they should give their approval or disapproval, whatever, right? So they will refer to the state for their basically consideration, for their consideration. So bill must be referred to the state. Now when they will refer to the state, two aspects we have to remember, whether they should reply within a particular time or not. You remember that case, in the amendment case, constitutional amendment, if the states are involved, if that bill has been referred to the state for their approval, whether they should reply to that within a particular time or not, that is there or not? No timing is there, right? No time is required. But here also in constitution it is not written like within this time they should reply. But when the president, when this parliament will refer that bill to the state, in that reference they will mention the time that you have to reply within 3 months, within 4 months, within 2 months, within 6 months. Like that the time will be written in the reference. So the timeline for consideration by state would be prescribed in reference. Okay, that's the first thing. Next is the Parliament can proceed with bill even if state disapprove. This is very important. This establishes center's authority over the state. That means state do not have this power to reject the bill, or basically even if they reject, the center still can go and divide the state. Generally they don't do that. They change the name and these all things because they need the support of the people and those all things. Generally they don't do that, but still they can do that. You take example of Jammu and Kashmir. There was no reference to the state, still Parliament did that. Right? Example is that Jammu and Kashmir reorganization. So these two facts we have to remember. And then the next fact is that both house passed the bill with what majority? Simple majority. This we have to remember. Underline the simple majority, because what I will expect at the end, will create this One short note, separately you should keep where the simple majority, where the special majority, because that's very confusing sometimes. Okay, so both house has to pass it, and then lastly the assent. Third is assent. Whose assent required? President. So can they reject? Yes, they can. But generally they don't reject because it has already come through their approval. Already prior recommendation is there. Reject? Yes. They can reject, withhold? Yes. Like a normal reconsideration, can this say? Yes. These all things they can do that. There is no restriction on the president. Even they can keep it as the pocket veto also. No required. So the president is the one who gives this recommendation. So this is the procedure under Article 3. Okay, this. Now suppose here, the important fact here is that suppose we want to seeding territory. Seeding territory means that if we have to give certain part of our constitution, our territory to other country, can we use, which article we should use? Can we using Article 2? Article 2 doesn't talk about anything to give, right? It's already only talking about the admission, establishment. It is not talking about like the giving or removing certain part. It's talking about the formation of new state, alteration of the area boundary of existing state. It also doesn't contain the subject matter of giving certain territory to other country. So when these two doesn't contain the territory, whether we can cede means to give our territory to Pakistan, Bangladesh, Sri Lanka or some certain country, can we use Article 2 or 3 to do that? That means, can we pass just the law with the simple majority and cede certain territory to other country? We cannot do that using Article 3. This was the interpretation made by the Supreme Court in Berubari Union case. Berubari was on a territory that was given to the Pakistan in the exchange of some enclave. So that was a dispute resolution. I mean, we ceded certain part to the Pakistan. Now, since Article 2 and 3 was not mentioning how we can cede our part to other country, you cannot use Article 3 and just pass the simple law. So, what you have to do? Amend the constitution. So, despite that, if you want to do that, you have to use which article? 368. You cannot do through Article 3, which you can do simple majority. No. Article 368 you have to use, and that's why the 100th Constitutional Amendment Act has to be done in order to cede certain part to the Bangladesh. You are able to link that? Yes. So, ceding territory, that is giving certain parts of territory to other country cannot be done through it requires constitution amendment as per Supreme Court in Berubari Union case. Example, 100th Constitutional Amendment Act, land boundary agreement with Bangladesh. Required the amendment. Under Article 368. So special majority is required. Lastly, Article 4. It simply says that any change in Constitution under Article 2 and 3, Article 2 and 3 should not be considered as amended So this amendment should not be considered. That means it requires simple majority, president recommendation, which is not required in the constitutional amendment, right? No foundation on president to give assent. Okay, so these are the interpretation of Article 4. So we have covered the micro topic 1. We'll go. This was the, by the way, the exchange of enclave. You see, this is the this part is Bangladesh. Just to understand, Bangladesh, West Bengal, and this is basically West Bengal. This part here we have this land boundary agreement. So we gave certain exchange deal next week to exchange 162 enclaves, which was border dispute between the India and Bangladesh, right? So that was the exchange. Here one point, remember, settlement of dispute settlement of boundary dispute does not require amendment to constitution. It can be done through executive action. Why? Because something disputed boundary, something is disputed. That means that's not part of our territory. If India also considered it as a disputed boundary, then it's not the part of the territory. So it doesn't require any amendment. We don't consider Jammu and Kashmir as a disputed territory. We considered it as our integral part of our country. Right? So if tomorrow there is any ceding of the Jammu and Kashmir or any part of it to the China or Pakistan, it requires the amendment. You cannot just cede it saying that it's a dispute. No, we don't consider that as a dispute. But if, let's say, certain territory we consider as a disputed boundary, then you don't need amendment, because we are not, as per the definition of Article 1, not considering that territory as the part of India. So if you want to give that, you are resolving that boundary dispute, which is currently not part of India, just a dispute, then there is no need of any amendment. Just the executive, that is the president order, is enough. Right? So this much detail is important for this particular chapter, and this is the question you series 2019. Try to solve, and then we'll go to the next topic. Simple. What is it? Not correct. Given above is a not cornea. No, correct. Not correct. Which are not correct? 3 and 4 are Not correct. So option C will be correct answer. This statement 1. Which of the following creation of the new state or alteration of the boundary of the state are correct? An amendment has to be moved in the parliament under article 368. Is it correct? No, not required, right? Which article is enough? Article 4 clearly says that it's not required. Ratification by 1/2 of the state is necessary after amendment is made by the parliament. Is this required? No requirement, right? Simple majority is enough. No requirement. Only one reference is required to the state. That too also not binding after whether they accept or reject. The legislature can be passed by a simple majority of both of the parliament. Correct or right? Right or wrong? Right. Simple majority. So only 3 is correct. Clear? Next, the Parliament of India may form a new state by separation of territory from any state or by unifying any territory to part of any state. Which of the following procedures are true in this regard? Again, they are asking on the procedure. By a simple majority and by the ordinary legislative process. Yes or no? Yes. Not required 360. Next, on the recommendation of the president, who usually has to refer the bill to the legislature of the states which are going to be affected by the changes proposed in the bill. Is it required or not? Recommendation of president is required or not? Yes. Yes or no? Yes. Have the president refer the bill to the legislature of the state? Yes. They refer, na? State. President has to refer and they have to mention the time. So this is also correct. On the advice of the Prime Minister to the President, can they do? Parliament of India may form a new state by separation of the territory from any state or by unifying the territory of India. Which of the following procedures are true? Is it required on the advice of the Prime Minister to the President? Can they do that? No. It requires ultimately the Parliament has to do that. Prime Minister cannot do that, right? So this is wrong and 1 and 2 will be correct. Okay. So next micro topic is the state reorganization. We'll take a break. And then we'll take 20 minutes break and then we'll meet again. 2 will enter now. 1 is completed. Now we'll go to this. This is micro topic 2. This is state reorganization. Yes, we have seen certain questions on this state reorganization. Basically, to reorganize the state, which power we use to reorganize? Reorganization means? Simple modification in state, their boundaries, like creation of new state, etc. So what is the constitutional provision to do that? Which provision we use? Part? Which part? First. Part 1. What is the article? Article 2, 3, 4. These somehow, some way we use. Mostly we use the article 3 and the 4 gives us power like the how to do that. Right? So that is the constitutional provision to reorganize the state. Okay. Now, here to reorganize means creation of the new state or the separation of the one state to another. For example, that you see Telangana, Andhra Pradesh, that's an example. Now, to do that, the question is that what should be the basis? First, what should be the basis on which we should do that? We should separate the state, right? So, the demand for the separation of the state, the basis was the linguistic basis. The language basis we wanted to, and the more demand was the basis of the language. Now, for the first thing, like there was demand of creation of Andhra Pradesh. A lot of movement happened, you know that. Earlier, it was the part of Madras, right? So, it wanted to be a separate state and then the Andhra Pradesh movement took over. For that, then different committees and commissions were started forming, right? So, that we have to, before going into this, what separation happened, that the basis of that is the criteria of reorganization became important to understand. To know the criteria of reorganization, you needed there are several commissions formed. Several commissions formed. Now, MCQ can be created on the formation of these commissions. So, what were the different commissions which were formed? The number one was Dhar Commission. It was formed in 1948. Dhar Commission, 1948. So, the major question in front of Dhar Commission was, can we reorganize or should we reorganize the state based on the language? So, linguistic reorganization was the question. Should we adopt it or not? The answer came as no. It said no. We should not reorganize the state based on the language. Why? If you start doing that, then there will be the 100 of the state you can create, because every region have so many diversities there with the language. That was the case. What happened is that Dhar Commission said no. So protest started. Then another commission was created called as the JVP Commission in 1948 only. This is very high powered committee because Jawaharlal Nehru, Vallabhbhai Patel and Pattabhi Sitaramaiah, yes, Pattabhi Sitaramaiah were there. That is not important. But JVP, you see the Prime Minister, Vice Prime Ministers are there, right? So very powerful. So this also the same question. Can we do linguistic reorganization? The answer came no. Again, the answer was no. Then again, protest was intensified, especially in the southern state, and then this Fazal Ali Commission came in 1953. Okay, Fazal Ali Commission, 1953. This commission, again the question of linguistic reorganization came. Should we do that? The answer came yes. Okay, answer came as yes. So based on this, they gave the yes, but with reorganization can be done? Yes, with following criteria to be met. So they gave certain criteria. So these criteria has to be learned. The first thing is that linguistic and cultural homogeneity. Linguistic and cultural homogeneity, that is, it should be the similar one. The second is that preserving and strengthening the unity and security of nation. We should not divide in such number of state which is threatening the unity and integrity, unity and the security of the nation. The third is that economic and governance viability. We are creating so small state that there is not enough generation of revenue for running the state. Then welfare of people. Such state is ensuring the welfare of the people. Okay, so these four criteria Fazal Ali Commission gave. That means they said don't just limit to the linguistic and cultural factor. Go beyond that. You have to consider unity and security. You have to consider the governance and the economic viability. You need to ensure that such kind of reorganization is leading to the welfare. So the four criteria given by Fazal Ali Commission. And which commission accepted it? It's the Fazal Ali Commission. Now the Fazal Ali Commission gave the recommendation like how you can do that, what can be the criteria, and then they also give this important thing, that is the based on Fazal Ali Commission, one act was sanctioned, that is called as the Reorganization Act, right? Reorganization Act, State Reorganization Act 1956. State Reorganization Act 1956 came into the picture. Based on this Reorganization Act only, we created the different states. So this gave the legal basis. Okay, how it can be created, the law was formed. Later on, other committees was also created, like the Shah Commission. Fourth commission was Shah Commission. Shah Commission. In 1960s it was formed, Shah Commission 1966, and based on this 1966, based on this Haryana, Punjab, Himachal Pradesh and these states were created. Then fifth is Justice Jeevan Reddy Commission. You know what this commission is? Justice Jeevan Reddy Commission? No? It was constituted in 2004, and based on this recommendation only, Telangana was created in 2014. Justice Jeevan Reddy Commission. Okay, this is important fact. So these are the 5 important commissions which are related to the reorganization of the state. And remember, this reorganization is very important topic in the mains post-independence history. There this reorganization is directly mentioned, and whenever you are writing the mains answer related to the reorganization, these commissions mentioning them is very important. Okay, so this was the about what is the constitutional basis. What we have covered is the constitutional basis as well as the different commissions which were created in order to reorganize the states. Okay, now what is important is that using this reorganization, how the different reorganization took place in India. So this you should have this idea, because sometimes the chronology can be created using this. So first 1960s, the bifurcation of Maharashtra and Gujarat. Earlier Marathi speaking and the Gujarati speaking were the one state. Now they were bifurcated into the 2. The second is 1961, write down 1961, creation of Dadra Nagar Haveli 10th Amendment. These are facts only, you should remember that and you know them, just note down. See, wherever this constitutional amendment you see, 10th amendment, 12th amendment, 14th amendment, these don't need to remember. That much we cannot remember. 36th. You see, Dadra and Nagar Haveli originally not the part of the country, we added. Then the 12th also, the French handed over the Pondicherry. These all required the constitutional amendment. Now, Nagaland, these all, the latest one is the Telangana and these two union territories. This all the fact, the chronology if you can remember. But some fact till here we definitely remember. The only confusion comes when it comes to the northeastern states. Very difficult to remember that. That's challenging. But yeah, we have to do that. At least major remember 1974 Sikkim, 1963 Nagaland, and Punjab we know SA Commission, Chandigarh, Punjab, Haryana. This much at least if you remember, then we can eliminate options. Okay, so this UT wala part will cover in the next class. That is, in the part after the states, because that will be the better place to cover. Now, next thing we will cover is the citizenship. That is, micro topic 3 is the citizenship. Citizenship. That is, we'll see the provisions of this, different provisions are there about the citizenship. One thing is that we have adopted the single citizenship, right? Single citizenship. It is inspired from which country? Britain. Borrowed from Britain. Single citizenship, no dual citizenship, right? So double citizenship is not there in India. Now, the power to give the citizenship or take away the citizenship, is it in the hand of union or the state? The citizenship, it's in the hand of union. So it's a union subject, because we are talking about the. So under 7th schedule, this citizenship comes under the union list. Okay, so these two are the important feature. Now, what is the next thing is that we have to know here is that this classification is very important. That is a simple classification is, see, any resident of country can be classified as two. Number one, either they are citizen or not citizen, non-citizen. These are called as aliens. These are called as the aliens. Okay. So those who are residing in India but not the citizen, they are called as alien. Now, why this classification is important is because there is difference in the rights they possess. There are fundamental rights, there are political rights, there are civil rights. Those rights, some rights are available exclusive to the citizens and they are not available to the non-citizens. That understanding that there the questions can be asked. Now, when it comes to the citizens, they have all fundamental rights. They have all fundamental rights. Okay, they have political rights. The political rights means right to vote, right to elected, right to get elected as a member, become minister, become the president, right? So those all rights are there with the citizens. That is, next is that the public offices are available only to the citizens, not to the aliens. For example, public office like, they cannot become president, right? Can a non-citizen become president? No. President, vice president, prime minister, chief minister. Certain public offices are there which are available only to the citizen. For example, judges of Supreme Court, High Court, Attorney General, significant posts are available only to the citizens. However, here it's not like that they don't possess any kind of right. They also have this fundamental right, all fundamental right, except, please remember this, except Article 15, 16, 19, 29 and 30. These 5 rights they do not possess, they do not have, except these 5 rights, other they have. Now why they don't have? See, this is prevention of discrimination based on certain ground. You can discriminate based on nationality, based on, you can give certain preference to Indian. This is about the jobs in the government. How can you give jobs to the outsider? It's so difficult. In some cases, we give the jobs to the Bhutan and other people are there. That reservation, you see when you fill the form of UPSC also, there is the mention of that provision. Article 19, yes, freedom of speech and expression, assembly, association, cannot create everything here, that is there. 29 and 30, it is a cultural and educational right, that's also the preventive. Now we are giving Article 21 is available to right to life. Everyone has, whether it is a citizen or non-citizen, they can live here, right? Now the political rights, no, they do not have this right to vote. These things are not there. Public offices, no, they cannot become the citizens, right? They cannot become the citizens. They will not get these public offices like the president and those things. Remember here, the fundamental duty they have to follow. Fundamental duty not applicable. Not applicable. Okay. Fundamental duty follows, here not applicable. This, remember, this is important. Fundamental duty they have to follow, but it's not applicable to them. So that's the difference between the citizen and the aliens. Okay, this is the first thing we have to remember here. Now let's go to the provisions. See this question, old question, but consolidate our understanding. What is the answer? Freedom of religion, can they claim? Yes. Protection of life and personal liberty, yes. Equality before law, yes. Freedom of trade and profession, they cannot claim. This comes under which article? Article 19(1). That is, it involves the freedom of trade, profession, movement, and those all things. As you know that the Article 19 cannot be claimed by the aliens, right? So on that basis, the question has been asked. Next, now we will see the different provisions. We have covered Article 1, 2, 3, 4. Article 5. What Article 5 says? Citizenship at the commencement of the Constitution. Citizenship at the commencement of Constitution. That means when this Constitution was commenced, Constitution came into the force, who will be the citizen of this country? That was defined by this particular article. They have defined, okay, on this day, these kind of people will be the citizen of India. What they define is that based on who born in India. If somebody has born in India, you will get the citizenship. Second, either of their parents born in India. See, I'm telling you, you don't have to remember this. This is just I'm giving the criteria based on which how they defined it. But I'm damn sure they're not going to ask. This becomes very complicated because later on they have identified some dates like the parent should have born after this. Some criteria are there. That much is not required. That complexity won't come. So citizenship. My point here is that they only define that okay, on this day, whoever is born in India before this day, they will be the citizen. Like that, they defined it. Okay. Then the second thing is that Article 6. Article 6 says that citizenship to persons migrated from Pakistan. So this also they have mentioned this provision, like they have migrated from Pakistan. So from Pakistan, that is, because they are divided, and many of the people wanted to be in India. So they gave certain time period. Within this, you come back. From suppose you are in the Sindh and you want to be in India, they gave certain time. You come back to India and we will give the citizenship. So the citizenship to the person migrated from Pakistan when division happened in 1947. Then what happened is that some people, if you see, this became Pakistan. Some people first went from India, they went to Pakistan. But later on they found like we should not be here. So they came back after some time. So for that also the constitution, which was made in 1950. But these all were happening after 1947 when the partition happened. Right, in the August 1947 only partition happened. So between 1947 till 1949 a lot of things like this happening. So the constituent maker made the specific article like Article 7 which said like it is for those who have migrated to Pakistan but later returned back. They can use Article 7 to claim that we are the citizen of India. Okay, so write a definition. Rights of citizenship for migrants. Citizenship to migrants. For migrants to Pakistan, later return to India. Now, what were the criteria and those, that detailing is not required. This much is enough to know this. Okay, next. This gives right to citizenship to overseas citizen of India, person with Indian origin, that right. Now, see, let's understand this. All articles. Now, if you imagine the condition, what was happening in 1947 between 1950. This is the time period, let's say. Now, there are different type of people who want to be citizen of India. First, who are born and within India only. Suppose you are from somebody from Madras, that point of time. He is born there, he want to be there. So by birth they should get the citizenship. So which article protects this? Which article? 5. Right? Someone who has born in India will get the citizenship. Naturally, very simple, right? But it was not only this. There were the things like some people were in the Pakistan and they wanted to come back to India. So for them also we should have provision, right? So which article protects this? Article 6. If you come from the Pakistan, migrate from Pakistan to India, you will get the citizenship. Then the third thing happened is that they went came back. So Article 7 protects their right. Okay, but there were some people who were living in, let's say, Japan, and they want to come back and have the citizenship. Some people are living in Indonesia and they want to come back and have the citizenship when the India got the freedom. Earlier, since they were not in India because we were colonized and they were living in some other country, they are coming back. So for them, we have Article 8. Right? Article 8 gives them right, okay, if you are living outside, but you have this origin in India. Your parent, grandparents, someone is there in India, you migrated to other country before and living there. You got the citizenship also. You leave that, come back to India, we'll give the citizenship. Clear? So these are the 4 articles addressing the rights of the citizenship to the different kind of people who have certain link with the India and want the citizenship of India. Okay, 4 articles. Clear? Now the 5th article, that is the Article 9. Article 9 here, before Article 10, there should be Article 9. Article 9. Article 9 says, okay, you acquired the citizenship of India, let's say. Later on, what you did is that you acquired the citizenship of, let's say, other country. Suppose you acquired the citizenship here, you are the citizen. Now, what you are doing is that you went to Sri Lanka and acquired the citizenship of Sri Lanka. Then you will automatically lose your citizenship of India. So, automatic loss of the citizenship, if you have acquired the other country's citizenship, it is because we have the single citizenship. You cannot have dual citizenship of one country, 2 countries. Right? So, write a statement. Person voluntarily acquiring citizenship of a foreign state, voluntarily acquiring the citizenship of foreign state shall lose the Indian citizenship. Shall lose the Indian citizenship. Loss of citizenship happens. Okay. Article 10 is not important. Article 11 is important. Article 11 gives the power to Parliament to regulate provisions of citizenship. That means, see, what this citizenship or the part 2 is doing is that, if you see till now, just 2 things they have done. One, who will be citizen of this country. Second, who will lose the citizenship. 2 only, right? They have not mentioned like how to get the citizenship later if I am not the part of it. Or after some time, if I want to become a citizen of India, what is the provision? So what the Constitution has done, Constitution gave the power to the Parliament. You make the law as per the requirement. So there is lack of elaborative provision for the gaining, removal of the citizenship. So many provisions are not there. That power has been given to the Parliament to regulate the provision of the citizenship, because the citizenship elaboration is not there, just they have defined these people will be the citizen. Now, in this capacity, what the Parliament did is that Parliament passed the law that is called as the Citizenship Act of 1955. And later on, that only we have amended, and we said that Citizenship Amendment Act 2019. Like that, we have amended several times. So, with this only, the Citizenship Act was passed. Parliament enacted Citizenship Act 1955. Okay, so this is the act they have created. Okay. Now, this act becomes important because original constitution is not telling us enough thing. Now today, if somebody is not fulfilling, somebody became the citizen, let's say, from the foreign country. Now he is not fulfilling the requirements. How to remove that? Those provisions are not there. So this act has the provision. This act has certain provision. First, how to acquire. It has acquisition. How to acquire the citizenship. Acquisition. How to renunciation. Renunciation means voluntarily leave the citizenship. I want to leave my citizenship. Then termination and deprivation. These four things are there in the citizenship. Okay, and this was amended. Sometimes UPSC asks how many times it was amended. Like the census, they asked about delimitation, how many times this was amended, because this amendment is happening. There are 5 times it has been amended. 1986, 2000 1992, 2003, then 2005 and 2019. These are the 5 times they have amended. This is in the news because recently rules were notified of the CA rules notified. That's why it is in the news. Okay, so what they have done is that they gave elaborated provision on how to acquire, how to voluntarily leave, how one can terminate, and how we can deprive them of their citizenship. These things has been made based on the situation. They have amended in 5 times. Now one by one we'll see acquisition. The acquisition, they have the criteria how to acquire. Acquisition means how to get Indian citizenship. They gave certain criteria. First, by birth you can get. Suppose you have certain birth relation, by descent, by descents, SC, descent. Third, by registration. Fourth, by naturalization. By acquisition of territory. Some territory has been acquired, so those people can become the citizen. See, this registration is for those who are non-illegal migrants but have certain Indian origin. They have certain Indian origin is there. Either their parents, grandparents, something, their origin, they link with India. But this naturalization without any linkage, without any previous linkage with India, without any previous linkage with India, that is called a naturalization. That means what you are doing is that you are staying in India for a long period of time, and through that you have naturalized, you have become natural to India now. Registration is what? You are already naturally Indian, living outside, just get registered. So the criteria is little less in registration, obviously. But naturalization, someone suppose is not do not have the natural linkage with India through descent, birth, or no linkages here. They are staying here for certain period because of the visa or some marriage relation. Suppose one man here married to some women from the abroad. Now she is living here. She is getting naturalized now here. Or some person is working here for long period of time. He knows the any Indian language out of the 22 languages. They have the allegiance to follow the Constitution of India. Certain criteria are there. They are getting naturalized, and then they have to, they also can get the citizenship using this provision. Next is by acquisition of territory. Suppose we acquired the Balochistan. The people of Balochistan can get the citizenship of India. Okay, so these are the 5 things for acquisition. Now, next thing is the loss of citizenship. Loss of citizenship can happen. The first thing is that by renunciation. First, by renunciation. It means what? Voluntary. Resigning, like from citizenship. I am leaving my citizenship voluntarily. Second, termination. Automatic loss. If acquired other country. Third is deprivation. Citizenship by fraud, somebody doing anti-national something against India. So government can take away their citizenship basically. That's called deprivation. Okay. So this issue came, NPR, NRC, CAA. This was in the news. This happened because of this CAA 2019. Let's cover certain things about CAA 2019 because it came recently. Rules came for that. That's why it is in the news. See, what has happened is that, let's revise. You might be aware about this. So, as you know, there are a lot of violence is happening against the minorities, especially Hindus in Bangladesh. Recently, mob lynchings and other things happened. Similar cases we have observed in Pakistan also, and also in Afghanistan. These are the Islamic dominant countries, and they have declared themselves as an Islamic country. India has not declared itself as a Hindu or Islamic country, right? So they have declared as Islamic country. So here there are some minorities who has been persecuted because of the religion by the majority. So the proper evidence is there for the Bangladesh also, evidence is there. So now what the government made the criteria is that if there is any person who belongs to certain religion, if religious persecution faced by minorities in countries of Afghanistan, Bangladesh and Pakistan. Citizenship criteria would be eased for them. Okay. Now the question is, which minorities? Can be MCQ. Here, Hindus, Christians, Parsis, Sikh, Buddhist, Jain. Any other is there? No. Hindu, Sikh, Buddhist, Jain, Parsis, Christian. Yes, these are the 6 religion from 3 countries: Afghanistan, Bangladesh, Pakistan. Hindu, Christian, Parsis. If they are coming because of religious persecution, citizenship they have reduced. Generally, it requires 11 years. I think they reduced to 5 years. Yeah. So generally, it requires the criteria to live in India to get citizenship reduced from 11 year to 5 years. So if you are, let's say, Muslim, you can get the citizenship. If you can get citizenship, but you have to stay for 11 years. But if you are from those criteria and you prove that you have been persecuted, then the 5 year is enough. So this much fact is, yes, they have this cutoff date 31st December 2014. Cutoff date 31st December 2014. Somebody came before this can claim it. Okay, somebody came before 31st December 2014. That much is, I don't think they will ask, but these states and the countries and the religion is important. Clear this concept? Now comes this, okay, when this came, Citizenship Amendment Act, this term also came in the news, that is NPR, National Population Register, full form. Okay, so this is about NPR, few facts. Legal basis, same, right? Legal basis, the first is Constitutional Amendment, Citizenship Act 1955. Ministry of Home Affairs does this. Registrar General and Census Commissioner, same body, authority who conducts the census also. NRC also. Now here, it is for this fact, remember, citizen as well as the non-citizen. That is called as the NPR. The next is NRC, National Register for Citizens. National Register of Citizens. Now here the facts are, this is also connected, legal basis is same, that is Citizenship Act 1955, they have to be citizen, but this is only for citizens, not usual residents. Only for citizens, not residents. This verifies citizenship. So highly powerful. If they didn't find your name in citizenship, that's why it happened in Assam, right? Many people were not getting their names. So what will happen to them? They are not citizens of India like that. So it's very important document, but only for citizens. Then in census, this is news. Census. Okay, census. It provides statistics on, right? It provides statistics on demography, resources, culture, and economy. and economy. Now the question is when it started. Started 1872. However, it was non-synchronous. That means it was not like the all India level, not properly synchronized. Then the next time 1883 was the synchronous census. The first synchronous census. The first synchronous census was in 1881 by W.C. Plowden. W.C. Plowden. He was the census commissioner. We'll cover every fact about this census, very important. I'm telling you the question very much expected from this topic. So W.C. Plowden was the person who conducted 1881, was the census commissioner. Okay. Now, what are the constitutional and legal basis of? You understood what it is? It is nothing but statistic, right? What is the history? This. Okay. Now, constitutional basis. What is the constitutional basis? We have to see this. Constitutional basis number 1. It is under Schedules 7, Union List. So the responsibility of census is in the hand of Union. Entry 69. Let's go more specific. So Union subject. Then the legal basis. (1948). What are the institutional aspects? Number 1, it is under Ministry of Home Affairs, nodal ministry. Then Registrar General and Census Commissioner is the authority of implementation or body. Okay. There is one provision that administrative boundaries are frozen 3 months before census begin. Frozen means administrative boundary means you cannot change after that the district. You must have seen in the state sometimes they change the district name, place, like that they will merge the district, they will create more districts. Those things you cannot do 3 months before. If they will do that, then it's very difficult to collect the data, right? It makes sense. But this data is important. Before how month? For the exam point of view, 3 months. Okay, that is important. Now what we have to see is that, let's see that the census 2027 from the current affairs point of view, census 2027. Census 2027. See, this is going to be the 8th after independence. It is going to be the 8th after independence and 16th of India. If you count from 1881, then it is 16th. Otherwise, it is going to be the 8th. It is going to be the first digital census. That first time, they are going to use the mobile phone to capture the data. Third, first time caste enumeration. That is, they will ask you what is your caste. Earlier, this caste was not there. Only SC, ST was there. OBCs were not being calculated. Only time it was, last time, it was in 1931. The caste census, which say, na, there was huge demand and it was also news. That's why this is first, this point is very important. This is going to the first of independent India, but not first for overall India. 1931 it was conducted. Okay, so this caste enumeration has been accepted by the government of India. It will be conducted in 2 phases. Phase number 1, that is called as the house listing. Phase number 2 will be the population enumeration. First they will list the house and then they will collect the data on the population. They have kept certain reference date. For example, reference date for India is the March 1st, 2027. Reference is required. Na? That is the date. You will say that on this day the population is this much. On this date the sex ratio is this much. Like that. So they have this cutoff date. But remember, one fact is that the cutoff date for certain state like Uttarakhand, Jammu and Kashmir are different. It is because the difficulty to collect the data in those regions. What for them, the March is not the date. For them, the October is the date. Because post October, this phase is something where you cannot go there to collect the data. Highly difficult time. And because of the climate, this harsh winter is there. Right? So that's why the different criteria is there, but I don't think that much is important. The year date is not important, but that concept, we have kept the different reference data considering the climate, because that can disrupt our collection of data. That fact we should remember. See the question. Only one, yes. Only one is correct. See, only by birth, no. You can buy naturalization. By registration also. If you have got the citizenship, you can become the citizen of India. But in US, it's not the case. In US, only by birth, you can become the citizen of, president of that particular country. But in India, if you became the citizen by naturalization, not by birth also, then also you can become the president. Okay, that fact we have to remember. This is absolutely wrong. I mean, it's not a citizen by birth only, it's also wrong. There is only one citizenship and one domicile. Either you can be domicile of the Andhra Pradesh or Telangana. You can't be of the both place, right? So that is the fact. What would be the answer? D. 1 and 1, 2, 3. Okay, let's see. Full civil and political right of the citizen. Yes, we get it right. All rights. The right of suffrage for election to the House of the People. Yes, and the Legislative Assembly of every state. Why they have kept this word agree? They could have kept here that Legislative Assembly of State. So this is something which creates suspicion whether it is right or wrong. So let's put it as doubtful. The right to become the member of parliament and member of legislative assembly. Yes, you can become. You can become it. Okay. So 1 and 3 are correct. Oh, well, I did. Picture. 1 and 3 are definitely correct. So this cannot be the answer. This cannot be answer. Now 1 and 3 or 1 to 3. See, to be honest, this creates certain doubt. Either it can be 1 3 or 1 to 3. I'm not sure here. I will be honest here. I'm not sure here whether it is every should be considered or not. Once you also check, I'll also check. Okay, we'll check this because this is a tedious question. Maybe asked in our exam also, CSC also. Do we get the right to vote in every state? We don't get that. No? I cannot vote in Andhra Pradesh. You cannot vote in Chhattisgarh. So when it says every state, by logic it should be wrong, right? Even if the UPSC later claims, then we can claim it that you have written the every now. So I think this should be wrong based on my understanding, and the answer should be 1 3 because of that every. Okay, so these are the different aspects of citizenship, including current affairs we have covered. Okay, any doubt here? Check once, revise quickly, go through your notes of citizenship. That is micro topic that of citizenship 3. I mean the micro topic 3 from from here, citizenship part. So the first is, it is single citizenship, union subject. Okay, quickly see. It can be either citizens or it can be non-citizen. Citizen has almost all powers, but they have to perform the fundamental duty. They don't have to perform. And then they have this, except these 5 rights. Except those 5 rights. What are those 5 rights? Article 15, 16, 29, 30 and 19. Right? So they cannot have these 5 rights. So that is the thing we have to remember. Then the article 5 talks about this diagram will help us. Where is it? This. There are 4 articles. 5 is who is by birth, already there. 6 who came from Pakistan. 7 who went to Pakistan and returned. 8 from Indian origin. Okay, so the 4 articles. The 10th was related to, the 10th was not important. 11th is important because here it gives the parliament power, and based on that they created this. Within this we have this acquisition and the loss of the citizenship amended 5 times. Then acquisition, 5 criteria: by birth, descent, registration, naturalization and acquisition. Then loss of citizenship, renunciation means voluntarily, termination means you adopted some other, deprivation means you have been taken, your citizenship you have taken. Then this CA, we saw this 2019. Then NPR, this is both citizen and non-citizen. NCR only citizen. Census, it is 8th, 2027 is the 8th one. We see them. The facts are very important. I'm saying this again and again. It's very important. Please keep in mind. Okay, tomorrow we'll revise this. So let's save this and then we'll go to we have 10 minutes. What is the date? 28, right? Okay. So for us, the next topic is going to be, that is preamble. We'll start this preamble, that is subtopic 3. Okay. We have covered subtopic 2, that is the union territories, and that we have covered the features as the subtopic 1. Now our third subtopic is going to be the preamble. Now let's first analyze the previous year question, and then we'll go to the covering that topics. Now, based on my analysis of the previous year question, I found two type of questions here. One, they are asking on the significance of the preamble. That is, what is its feature, whether it is amendable or not, is it part of the constitution or not, like that they are asking. That is significance and features they are asking. Second, they are asking on the keywords which are there in the preamble. Keywords, like there is some word like secularism, socialism, democratic, republic, these words are there, no? So they are asking the definitions of those words. What does it mean, like that question? So our approach is we are going to divide into the two micro topics. One, on the significance and feature, when adopted, what is this feature, significance, and those all aspects. Two, what we will cover each and every keywords which are there in the preamble from the prelims point of view. We will try to understand them, the key aspect. So that is going to be the strategy to cover the preamble. Okay. So as you see the preamble, the question number 1, see this 2017. Objective is not embodied in the preamble of the constitution. Yes. So it's directly the significance, that feature, what is there inside. The mind and makers of the constitution of India is reflected in which among the following. It's also significance, right? Where the mind is there. Significance. The preamble to the constitution of India is part of the constitution, not part feature again. Then see the significant keywords question. One of the implication of equality in the society. Equality is the keyword there. Okay. Democracy is superior virtue lies in. The word democratic, it's mentioned. We are going to cover. See, I am not saying that this question will be from preamble. This question is from preamble. They may take from the NCERT also. It might be from NCERT also. It is from NCERT actually. But the thing is that preamble is a document which keeps all the major keywords of the constitution in the top. So if we cover those keywords, our job is done. We don't have to read the NCERT. Okay. So that's why we'll take that. See, democracy. Following reflects the most appropriate relationship between the law and liberty. Liberty is the word there in the preamble. In the context of polity, which of the following would you accept as the most appropriate definition of liberty? Again, liberty word, we'll cover that. Liberty word again in 2023. So, like this, there are keywords which we have to cover, like the liberty, equality, democratic, socialist, secular. These keywords we'll cover under the preamble. Okay. So that is going to be our strategy to cover this. We'll cover into the two important micro thing. Yes. Yeah. Topic 3, preamble. So this is subtopic 3, preamble. Let's divide this. Within this preamble, that is subtopic 3, within the topic of constitutional framework only, we are in the first topic only. Within this, we are going to have two things. That is micro topic 1. That is, we are going to cover the features and significance of preamble. Second, micro topic 2, we are going to cover the keywords in preamble. Keywords in preamble. These are the two things we are going to cover in this particular segment. Understood the preamble, what they are asking? So we have to be strategic. That is the funda here, right? Should not read the Lakshmikant like blindly. As you now aware like what exactly they are asking, you should be very focused. right? So now let's see. First is that features and significance within this. Few things we have to be very much clear about this preamble. First is that it has been defined as the identity card. What is it? It is an identity card of Constitution. Identity card of Indian Constitution. Now when it says identity card, who said this? It has been said by the Palki Wala. It has been said by N.A. Palki Wala. N.A. Palki Wala. See, may not be directly asked this name. That will help you in the mains. You can conclude, you can introduce using that. But which among the following is called as the identity card of the Constitution? Like that question can be created. It is simple, but yet we should be aware. That's the first fact. Second, it has been inspired from two things. First is that US Constitution. US Constitution also have this preamble like the US Constitution. Second, it has been derived from objective resolution. You know this objective resolution, right? I don't need to explain that. That's objective resolution. Okay, so these are the three important aspects. Next, act as basis of interpretation So judiciary, as they interpret, they can use this preamble to interpret. Next is, these are non-enforceable provisions. These are non-enforceable provisions. It was included at the end of Constitution. At the end, we adopted this preamble, though we kept at the beginning, at the end, so that the values which are there in the preamble should be in sync with that. Next is amendability of preamble. Whether it can be amendable or not. Now, for any provision in the Constitution to be amendable, it has to be part of it. Then only you can amend, right? Because Article 368 clearly says that the constitutional provisions on the different parts can be amended. But the dispute was first we have to decide whether it is a part of our constitution or not. Then only you can decide whether it is amendable or not. So there are different judgments regarding this, and finally we came into some conclusion that we will cover in the tomorrow's class. Today we'll close here, and key features we have, certain features we have covered. We'll see the amendability and whether it is part of it or not. We'll then see the derive different information from here and try to solve certain questions based on this features of the preamble, and then tomorrow we'll finish this preamble topic and other aspect also. Okay. Thank you.